Mr. Albee.
Judge, the bottom line is this one-page statement is basically all exculpatory, and then it adds a handful of negative facts. And it's my belief he constructed this out of both materials in Mr. Jensen's cell and from conversations with Mr. Jensen, and then was able to use the materials to make additions to this kind of statement. And so I want to go through with how he obtained this information and had it put in a statement.
I don't understand what counsel is talking about, Your Honor. The fact of the matter is this is a hearsay statement, and it's not inconsistent with the witness's testimony. Now, if it were inconsistent, then it's a prior inconsistent statement.
We don't need to talk about what could be. The bottom line is what you're asking me to do is allow you to go through a hearsay statement to show how it was assembled, but it's still a hearsay statement.
I'm not offering for the truth.
Well, then
it's irrelevant.
No, it's because it's how he constructed it.
Well, how he constructed it is how he came up with a story. The creation of the hearsay statement is merely a written memorialization of the account. So it's the creation of the account that you're questioning, not the creation of the hearsay document.
But I need the details of how he created it. I mean, where did you get this information, and you inserted this?
Which you can ask him without reference to the written statement.
And well, he already has asked this witness extensive questions about where he got the information and asked him about newspaper articles and so forth. But I don't understand how that has anything to do with his witness statement. This is a hearsay document, and it's not inconsistent, as near as I can tell, in any way with the witness's testimony.
Well, I can also, I think I can even introduce it as a script, because the notion that he hasn't reviewed any of these things in the last 3 weeks, I think is...
You know, you're really asking way too much of me, Mr. Albee, when you ask me to assume that a witness is a liar in making an evidentiary ruling, which you do when you say these things.
No, I'm assuming that I have a good faith basis for that argument. I of course don't. I'm not asking the court to be a fact finder, but I think I would need this as a predicate to make that, because the jury hasn't seen this, so they can't draw that inference right now until I present it.
Why should they see it?
So that they can draw the inference that he's lying when he says that he hasn't reviewed any documents, because his testimony so closely tracks this statement.
Now this is a first. You're saying to me that the proof that the witness is lying is that his testimony is just too consistent with what he said in the past.
Yeah, it's memorized.
That certainly, I can't rule that out. But it's also possible that his story is consistent with his past statements, because it's the truth. And it's not for me to decide, it's for the jury. And I understand you have a right to try to show that he's not being honest, but...
Your Honor, if counsel wants to introduce this document into evidence, I have no objection to that. Now, show it to the jury, let them read it. Let them see how this witness's testimony is completely consistent.
You want to accept that? And don't be surprised if it ends up there.
Yes, and also don't be surprised if the letter that he wrote to his lawyer previous to that is then being offered as a prior consistent statement, being offered to rebut an inference of recent fabrication.
It's not recent fabrication.
No, I will not hear argument on an objection that cannot even yet be voiced. So if you want to take him at his offer and put this into evidence, then we'll have to deal with what comes up after.
Understanding this will come up after.
Well, I'm understanding nothing.
Well, Your Honor, I will only agree to this document coming in. The this statement,
Has this got a number, by the way, so that the record will reflect what we're talking about?
Yep, it is marked. It's in
What is
front
it,
of.
number what?
D-135?
139.
sorry, D-139.
Is that, are you going to accept the stipulation to offer it into evidence?
Not yet, no.
And the stipulation, Your Honor, is it can come into evidence, understanding that D-140 is going to be the letter that he wrote to his lawyer.
Well, I'm not going to.
As a prior consistent
I'm not going to
statement.
conditionally admit something. Either we'll have to, each paper will come in on its own merits.
Well, in that case, Your Honor, this is a hearsay document. The state objects to it being introduced into evidence. And furthermore, unless counsel is going to be examining the witness about a prior inconsistent statement in D-139, I object to any further cross-examination on it.
I think the bottom line is I think the document's hearsay. All right. Would you ask the jurors to come back in, please?
Mr. Dillard, while in the Kenosha County Jail, you had an opportunity to review a transcribed interview that took place between Detective Ratsberg and Mark Jensen, right?
That's correct. Oh, hold on a second. Did you say transcript between Klug?
No.
Oh, I was thought.
Mark Jensen and Detective Ratsberg.
Oh, no. Only Mark Klug. Or Klug.
You deny having read that transcript?
Correct.
You deny having read anything in that transcript where Detective Ratsberg was talking about Julie's body being rolled over?
No, I never read anything like that or talked about it.
Do you not deny reading anything in that transcript about...
Objection. The witness has said he didn't read anything in the transcript, and now counsel's just trying to introduce statements that are not before the jury otherwise.
I'm going to bear with it briefly.
Yeah.
Go ahead. In light of the fact that it's cross-examination, go ahead.
Do you deny reading anything in that transcript about Detective Ratsberg accusing Mr. Jensen of pushing Mrs. Jensen's face in the pillow?
I never read a transcript of that.
Do you deny reading anything regarding Detective Ratsberg's claims during an interrogation of Mark Jensen?
Yes.
Tell me what Mark Jensen said about his concerns about Julie's treatment of the children.
He said that he was upset with it. He said that she was crazy, and he was angry because of the fact that, like I said, she'd have one kid would come home from work, and one would be naked in one room, and one would be naked in the other room.
What were the circumstances under which Mr. Jensen said he came home and found one child naked in one room and one child naked in a different room?
The circumstances, I'm guessing time, day, and things like that, or what do you mean?
Whatever you know about the circumstances in which that took place.
He said it was later at night when he came home that happened. As far as anything else in regards to that subject, he just said she would do things like that a lot.
Did he say why the children were naked?
No.
Did he say why he came home later at night?
No.
Did he say why the children weren't in bed if it was later at night?
He did not.
What else did he say about Julie Jensen's treatment of the kids?
He said, let me think. That's the major one. Then he said something about something happened at a restaurant. She would snap at him like a couple occasions. She would yell at him in the restaurant, cause scenes, and then they would try to go out with friends and they'd cause scenes.
And none of those things about the kids support a confession that Mark killed his wife, right?
I don't believe so.
He told you that she was taking medications for depression, right?
That is correct.
What did he say about his wife's depression?
Just said she was crazy, that she was nuts, that she was always never here nor there. She was just wild, I guess is what he said.
You were aware that the prosecution was accusing Mr. Jensen of killing his wife with antifreeze, right?
Yes.
That was well known, correct?
I believe so.
Did you read newspaper accounts of the hearings in August?
The only newspaper article I got to see was basically the Klug articles, because I really didn't get to see any newspapers prior to any of this, because I was in more solitary kind of thing.
So you knew about that even coming in, about Mr. Klug, right?
Yeah, that's why I believe why I made the comment of him being pretty popular.
And in Mr. Klug's transcript, is there some discussion about this time in November when Mr. Jensen couldn't reach his wife when he was calling?
Yeah, I believe that the statements, Klug's testimony said that he was trying to call his wife and that he would repeatedly call her.
And Mark told you that he had been trying to call his wife and that she wouldn't answer the phone, right?
Objection to the form of the question, Your Honor. When he says he, is he referring to Ed Klug or is he referring to Mark Jensen? Which person and which
It's fine.
wife?
I'll re-ask it. It's okay. Mark Jensen told you that when he was in St. Louis, Mark Jensen had called his wife repeatedly and she didn't answer the phone, right?
I don't remember if he said that or not. No, because I think the conversation we had about her only pertains to her throwing up all over the house.
While he was in St. Louis.
Yes.
He came home and found that she had vomited on the carpet.
That's correct.
He said he called the carpet cleaners to have that cleaned up.
Yeah.
And did he say that when you claim he confessed, did he say that was antifreeze?
He didn't say how that happened.
He told you that this was a sign of his wife's depression, correct?
I don't believe that's how that got introduced.
How did it get introduced, Mr. Dillard?
I believe that got introduced as far as the point of when, I believe that's when he was telling me that he screwed up and poisoned her before she left. That's how I found out about the throwing up all over the carpet.
Well, wasn't that part of your discussions about Mr. Klug because it was in the Klug transcript?
About him poisoning her before?
No, about there being an episode in St. Louis where she had gotten sick, when Mark was in St. Louis when Julie had gotten sick?
I don't remember that being in the Klug testimony. I don't remember if it was there or not.
And to sell your story to the prosecutor, all you really needed to do was add the part about antifreeze being mixed with juice, first of all, right?
No.
Objection, Your Honor. Calls for speculation as to what this witness would be needed to sell his story.
Well, you wanted to get credit for this case, right?
I wanted to get a recommendation. I don't know what kind of credit you mean. What kind of credit?
When you wrote your lawyer, Mr. Dillard, you wanted some consideration for making statements against Mark Jensen, right?
Yes, I wanted to be safe.
Mr. Dillard, you wanted to not spend time in prison is why you wrote your lawyer, right?
That's not correct. I don't want to be the jailhouse snitch in prison.
The reason you became what you call a jailhouse snitch is because you wanted credit for saying things about Mr. Jensen, right?
I wanted my safety protected to be, I wanted my safety to be enforced to give information. I did not want to be in prison being the one that snitched on somebody.
Were you trying to get some release from prison or some other consideration in respect to your imprisonment through making statements against the accused?
Yes.
In fact, you wrote your lawyer in paragraph 2 of Exhibit S-134, Mrs. Rosenke, I would like to know if you can work a deal with the DA in my cases for the information I have in this case, exclamation point. I would like to know if I can get my record cleaned up and can get out of jail, or at least be released and have my supervision reinstated, but up in Milwaukee at minimum.
Yes, that's correct.
right? And then you go on to say, I'd refuse to testify if I were in jail, right?
That is correct. I told you I do not want to be the jailhouse snitch in prison.
Right. But the first thing you asked her is, do I get consideration for this?
Objection, Your Honor. Under the doctrine of completeness, I believe the remainder of the
Judge,
witnesses...
that's for cross-examination. I'm not done with my examination.
I've got it here.
Right, first and foremost, you wanted to do this to get yourself out of jail, right?
Yes.
And then, in addition, you were saying, I refuse to testify if I were to be in jail, as I will have fear for my well-being, right?
Absolutely.
Right. But that also gives you a little bit of leverage to insist that you be let out of jail, right?
Leverage, I don't know. I'm not sure, but I think I read in the paper an article that somebody actually did threaten my life. So if I was in prison, I believe it's a well-founded
Objection.
fear.
Move to strike. Well, I guess the objection. I move to strike his volunteered answer.
Objection, Your Honor. I believe that the answer was responsive to the question that was posed to the witness.
Well, I'm going to order it stricken for a variety of reasons, one of which is that he read it in the paper, and that is not of the caliber necessary for it to be received in the court, at least on the point in which he appears to have, on the point for which he appears to have offered it. So disregard it entirely. Go ahead.
When you say, I refuse to testify if I were to be in jail, that's trying to get leverage against the prosecutor, that either they let you out of jail or you won't tell your story.
It's not correct.
You are now willing to acknowledge that number one was getting you out, right?
Yes.
Let me give you Exhibit 134. And you have 139 in front of you.
What's 134?
It's the, no, it's the letter.
This?
Yeah. Here are my copies. Mr. Dillard, as I understand it, it's your claim that Mr. Jensen told you that Julie Jensen was sleeping on her back and her breathing had improved. Is that right?
I'm not sure if it was her back or side. I don't know what I said.
Well, I'm asking, excuse me, I'm not asking you to read those right now. I'm asking you what you recall.
I believe she was laying on her side.
She was laying on her side initially?
Yeah, I believe she was laying on her side.
And was she turned from her side to some other position?
To her face, to her stomach.
And so it's your understanding that Mr. Jensen told you that she was turned so that she was flat on her stomach, right?
Yes.
Is that what Mr. Jensen told you?
Yes.
And that while she was on her stomach, she had her face in the pillow, correct?
Yes.
Well, is that what he told you or not?
Well, he told me he pressed her face into the pillow.
Okay, but initially he turned her and she was on her stomach with her face in the pillow, right?
I would have to assume it was in the pillow. He didn't specifically say her face was in the pillow.
Well, if you look at Exhibit 134, is it 134, the letter to your lawyer? The page 5, bottom of page 5. And where the beginning of the last sentence there, it says, so he rolled her. Do you see where I am?
Yeah, I think I do.
So he says, so he rolled her over on her face with her face in her pillow. He thought that would make it hard for her to breathe. He left her for a bit and came back and she was still alive, right?
Hold on, I was actually down a little farther when I said that she was sleeping and he rolled her over a bit and she did not wake up. So there's two parts where it says those words. Where's the first part you were talking about again?
I'm talking about the sentence that the first 4 words of the sentence are at the end of that page.
The end of page 5?
Yes. So he rolled her. You see that?
And he rolled her, or
so he rolled her. The last 4 words of the page.
Oh, so he rolled her, okay.
Over on her face with her face in her pillow. Did I have that correct?
Yeah, so he rolled her over on her face with her face in the pillow. Yes.
Correct. So that happened first, is what he told you, according to your letter.
Objection, Your Honor. Under the doctrine of completeness, I request that the preceding sentence be read.
Judge, the doctrine of completeness doesn't apply in this, and I don't have to do it in the order that Mr. Jamboys would like.
Your Honor, just a minute.
And Judge, the reason I'm reading this is because initially he said he didn't recall that Mr. Jensen saying that he rolled her over on her face until the point where he said he pushed her.
Read the whole, the preceding sentence also.
Is that
Mr. Dillard,
Yes.
starting with the prior sentence. Said she was sleeping on her back and he rolled her over a bit and she did not wake up. So he rolled her over on her face with her face in her pillow. He thought that would make it hard for her to breathe. He left her for a bit and came back and she was still alive. Do I have that right?
Yes, that's what it says here.
Is that what you remember or not?
Now that I recall the statement, that's how it happened.
It says, then he got up on top of her and pushed her head, and then you have in parentheses neck, into the pillow and sat on her back so she could not breathe and she died and you went to work. Is that how you remember it?
Yes.
And it's your recollection that what Mr. Jensen told you is that she was turned onto her stomach, her face was in the pillow, and he sat on her back. Do I have that right?
Yes.
Now, the Defendant's Exhibit 139, the typewritten statement,
Yes.
that was typed up by the District Attorney's Office, right?
That's correct.
Based on information that you provided them, correct?
I believe so, yes.
If you go to the second paragraph, Mr. Dillard, and let's go to the last 3 sentences. It's beginning with, he said that he then rolled her. You see that?
Yes.
And in this version, it says, he said that he then rolled her from her back onto her side, correct?
Yeah, but this, yes, it does say that.
And he sat on her back, right?
That's what it says here, yes.
How could he sit on her back if she's on her side?
I don't believe I ever signed this statement, and I don't believe that I had a chance to say if it was all accurate or not. I think I testified that earlier, that I had no knowledge. I've had knowledge of what was said at that meeting, but I didn't review the statement with them and approve it and say that it was what it was.
Okay, let's go to the next sentence.
Okay.
He pushed on her lungs and her head until she stopped breathing. Yes?
Yes,
I read
sir.
that right?
Yes, sir.
And your first statement doesn't include anything about pushing on lungs. That's another discrepancy, right?
Well,
This other statement is not his.
Well,
It appears, according to what he's claiming, it's a summarization prepared by someone else.
I know the court might find it hard to believe. I have a point that I'll be getting to momentarily. That's important.
Well, go ahead.
The lungs you did not say in your first statement, correct?
This is a statement, like I said, that was typed up by somebody else. I believe I said he pushed on her back and that restricted her lungs.
Well,
Or the ability for her to breathe.
right. Your recollection, what Mr. Jensen said, is that he pushed on her back, right?
No, he sat on her back. I think he pushed on her neck.
Okay. Not pushed on her lungs, he pushed on her neck while sitting on her back.
Yeah, I think him sitting pushed on her lungs.
Okay. And let me see if this reflects the differences in the statement. Is that on?
Show to the judge, I object. And did you want to hear the grounds for the objection, Your Honor?
Not yet. Well, I think that the issue I just raised a moment ago is the concern that I have.
I don't recall precisely.
He denies approval of the, I don't have the exhibit number, is it 135 or 130? 139 is the,
Well, this is what, it could be what the DA says, the district attorney's office says, was said, because they typed it.
You know what? I think I'm going to ask you to step out for a minute. Please don't talk about the case. It looks like you're trying to impeach him with a statement that he is denied is his own.
I don't know that I'm impeaching him on this. Let's say I find it curious that his statement has been modified to reflect the theory that's being promoted by the prosecution that's consistent with their photographs. The photographs are not consistent with what Mr. Dillard had to say. But then when the DA has a chance to type up his statement, she's now on her side and there's pushing on the lungs. That's curious in the sense that they are aware of what the autopsy report and the photographs show, and now there's been a change in how it's been typed up. That's, I think, problematic and relevant and open for me to argue to the jury after putting in the differences between the statements.
Did you want to respond?
Yes, Your Honor. First of all, I believe that the letter that Mr. Dillard wrote to his attorney precisely supports the description of this murder from Dr. Chambliss's perspective. I think it fits it to a T, and neither Ms. Gabrielle, who typed up this exhibit, was it D134, the typewritten statement? I forgot which was which, but is this D134 or D139? Okay, D139 is a statement that Ms. Gabrielle typed up after we had interviewed Mr. Dillard in the county jail with his attorney present. So his attorney is available to, I suppose, to testify about the circumstances surrounding the statement. It was a summary of a brief interview that we had with Mr. Dillard in the presence of his attorney to just to get a more thorough understanding of what it was he was saying. And at the time that, and this document, the typewritten statement is dated September 21st, 2007, and neither Ms. Gabrielle nor I had an opportunity to listen to the cross-examination of Dr. Chambliss and compare it to the photographs and compare it to the autopsy protocol, which is something that I did during the cross-examination of Dr. Chambliss. And it wasn't until after the cross-examination of Dr. Chambliss that I presented Dr. Chambliss for the first time with these photographs that he'd never seen before, and for the first time asked him to consider those in relation to what Mr. Dillard had told us. So on September 21st, 2007, neither Ms. Gabrielle nor I had any idea that Dr. Chambliss was going to be testifying about the cause of death in this case, and testifying in a manner which, as it turns out, very precisely corresponds to either one of these descriptions, either the one in D-134 or the one in D-139. But if it corresponds to any of them more particularly, I would say it corresponds more precisely to the letter, which is more detailed, than it does to the statement, which is a summary. Now, having said that, this witness has never affirmed that this statement accurately reflects in every detail his description of what occurred. I don't think there's anything here which is necessarily inconsistent in D1 in this typewritten statement, but the typewritten statement was clearly far more of a summary than the testimony that's been elicited here today, and actually it wasn't even as detailed as the statement that this witness provided to his attorney while these matters are still very fresh in his mind. So if counsel is, if the thesis here is that the DA's statement here more precisely corresponds to Dr. Chambliss's theory of the case than the letter, first of all, I think that's mistaken. And secondly, there's no way on September 21st that whoever typed that, when Mrs. Gabrielle typed this statement up, she would have any way of knowing what Dr. Chambliss was going to testify to about cause of death, since he had never offered us an opinion concerning cause of death.
Well, Judge, this is the third or fourth probably instance where now we find Mr. Jambois and Ms. Gabrielle as witnesses. It's a problem. I mean, we have a number of instances, for instance, with our police reports, for example, where Detective Ratsberg says something where the witness doesn't. I'll ask the witness about it, I'll ask Detective Ratsberg about it. And a lot of times, there probably are times when I want it to go one way, and there's probably times I could care less. It's going to impeach somebody. But the problem is, Ms. Gabrielle types this statement. I think, I don't have to accept what Mr. Jambois says. I find it very curious, and it's all I'll say. I mean, they've had the autopsy protocol and the pictures for a long time. I find it curious that we have this lungs thing there that's added. I find it curious that it's the side instead of on her back, and that matches the pictures. And as this court will recall, when I was complaining about lacking notice of Dr. Chambliss' suffocation testimony, I got a lot of, well, it's been obvious for a long time, and certainly since Aaron Dillard gave his statement, that you know, this could be coming out, that it would be suffocation, because that's what Aaron Dillard said. And so I take it that it would be reasonable that they reevaluated some of their evidence after learning about what Mr. Dillard said. They looked at this, and they thought, well, that could be close, but it's a little bit better here, and I find that curious, and I'm allowed to argue that curiousness to the jury. It doesn't smell right to me.
Well, Your Honor,
I have to tell you, I agree with Mr. Jambois in his statement that the original letter by the witness to his lawyer is more in concord with what Dr. Chambliss's version is than is what was typed by the district attorney.
Well, then I'm the loser in this, and nobody should care.
But the point is that if I'm right about that, then your argument is deflated.
Well,
Or either that, or Ms. Gabrielle thinks more like you than like me.
Ms. Gabrielle would, I'm sure, take offense to that, Your Honor.
Well, anyway,
But the point is it's
I'm not
irrelevant.
seeing it. And the bottom line is that it is a statement that the witness has not adopted as his own, and you can't impeach him with it any more than you can impeach him with a statement that he made to a police officer that's not signed. You can call the officer, but you can't offer the hearsay document without presenting the officer on the stand.
So this is just another subject I have to call Ms. Gabrielle on.
You know, we've discussed that before, and I've stated if that's what has to be done, that's what has to be done. I have imposed no impediment to you about having Ms. Gabrielle testify.
If that's going to occur, though, Your Honor,
We have to take some measures, but
for one thing, it would be my understanding. I would object to her testifying unless there's going to be an agreement that she's not going to be disqualified from the case, because I require her assistance.
Look, I'm not going to touch an issue that I don't have to. Why should I even waste the time to hear it now if it never presents itself? I'm telling you that because Ms. Gabrielle was a witness to statements made by other witnesses,
As was I.
the defense has a constitutional right to call her, or if push comes to shove, you, and the fact that you're prosecuting the case is not an impediment to that.
I understand it, Your Honor, but on the other hand, when considering that, let's consider the potential that there were other witnesses there, and one of those witnesses would be much less problematic. Like, for example, if Gretchen was there.
We're not there. And now we're not even to push, much less shove. So let's not talk about it. But the bottom line at this moment is the objection is sustained. Ready for the jury?
Yes. Please be seated.
All right, and the objection has been sustained. Go ahead, Mr. Ali.
Mr. Dillard, Exhibit 139, that's the typewritten statement. Correct?
Yes.
Is there anything other than the portion I read about the legs and her back and her side that you find inaccurate?
Give me a second to read it. Everything seems pretty similar. It's just
Objection. I don't know. I thought that the question was to have him read it. If there's any questions concerning the document, I object to any questions concerning the document. It's a hearsay document, and
The objection's overruled.
Is there anything else in this statement besides what you noted regarding the rolling from the back onto her side and sitting on her back and pushing on her lungs that you think is inaccurate?
the only thing I can say is just from reading it, just gives it like it happened. This conversation happened in a fast manner, and it all happened real quick. It's more drawn out than this. That's all.
But the facts therein are accurate?
Fairly, yes, I would say so.
I would move Exhibit 139.
objection is hearsay. It's consistent with his testimony. That's,
If he's,
it's also irrelevant, Your Honor.
he's expressed a present adoption of the statement with the
with some
reservations
exceptions
indicated.
And so let's say that he also read a newspaper article.
Just a minute. Hold
It's
on a
just
second.
irrelevant.
Hold on a minute. I think we're going to break for the day, for the week. And we'll start again on Tuesday at 8:55. Win or lose. Is anybody going to the game?
8:55.
I knew I had a smart jury. Enjoy the weekend and the game.
Your Honor, I think you should remind the jury once again.
By all means, you've got plenty to talk about this weekend. There's the weather, there's the Packers, there's plenty of other things. Please do not talk about, listen to, watch, or read any account of the trial. Don't listen to anyone else. again, if someone approaches you and knows that you're a juror or some way finds out that you're a juror and wants to discuss the case, just cut them right off. Don't be afraid of being thought rude and say, yes, I'm a juror and I'm not allowed to talk about it. And we'll both be in big trouble if we do. And if they persist, then walk away. And any questions? Thank you.
Please all rise.
You know, for starters, I'm having some I don't want to say second thoughts about what I said last time the jury was out of the room. Let's call them 1.5 thoughts. About which account is more concordant with Dr. Chambliss's testimony. So, who wants to lead off?
Well, Judge, second thoughts are good. Because the difference is that she's in the handwritten statement. I mean,
by the way, you can step down, sir. I'm sorry, go ahead.
Did we want Mr. Dillard to remain in the courtroom during this conversation?
I think not. That would probably be good.
You're welcome to leave for the day and return on, what time do you want him back?
Tuesday at 8.
Or do you want him to remain in the building for the while?
No,
Tuesday at?
Tuesday 8:30.
8:30.
Can I make one statement, though, as far as the statement? I didn't sign it, and I don't know what it says, so you know what I mean?
Well, all right, we'll take it from where we're at. Go ahead, I'm sorry about the interruption.
Of course, what I find, the difference is that in the original statement, Mr. Jensen supposedly says that she's on her stomach. That is, there's no photo of her on her stomach. There's no testimony that she was found on her stomach. And then it's the typewritten statement. Now it's changed to being on her side. We also now have the new information about pushing on the lungs, where there's some petechiae that's could be completely attributed to postmortem artifact, but Dr. Chambliss says could be consistent with suffocation. And so I think there are some new facts added in the written statement that enhance what was originally said. So I do, again, want to use it to bring up that fact. Also, the witness statement, like many police reports, I mean, I presume that, well, he's now said he's read it, and it's accurate, with the exception of what he noted there, should be admissible. I want to use it for comparison purposes because I intend to demonstrate in this trial how he constructed this statement, and I need something so the jury can understand that, something besides their memories on that.
Did you want to respond?
Well, and by all means, Your Honor, I encourage second and third and fourth thoughts about things. I want the court to make the correct decisions in this case. My objection to the use of this witness statement is that the witness, it's irrelevant. And the fact that the witness now reads it and says, well, yeah, that's pretty consistent, except for this one part, which, by the way, is the one part that is really at issue here. And he said that the previous statement that he gave in the letter was, I believe he's indicated that's the more accurate rendition of what occurred, that this was a summary. And he indicated that he's never signed this statement. He indicated that under oath, and there's no signature on this document. And now counsel asked him to read it. And the only thing that's changed between the court's earlier ruling and now is that counsel asked this witness to read this document on the witness stand. Well, let's say there was a newspaper article that had been released about Aaron Dillard's statement, and counsel gave him the newspaper article and said, is that accurate? And Mr. Dillard read the article, and he said, yeah, that's pretty accurate, except for this one particular point here regarding, you know, insofar as there's a discrepancy between what's in what I'm just reading here and what's in the earlier statement that I wrote to my lawyer. Well, matters were fresher in my mind when I wrote it to the lawyer, and the thing in the statement to the lawyer is more detailed and it's more accurate. Does the Does the newspaper article come in? Just because a witness reads a...
And the reason I ask is because what is the definition of a hearsay statement? A hearsay statement is a statement made by a declarant other than while testifying on the witness stand as a witness. Now, if you bring a piece of paper that was drafted by someone else, and on the witness stand while under oath, he acknowledges its accuracy, it seems to me it's no longer the declarant's out-of-court statement, but rather his in-court statement under oath.
Well, Your Honor, if that's the second thought that you had,
No.
that's wrong. Because the fact is, then you could say that about anything. Because let's face it,
But what is the hearsay rule designed to keep out? Inaccuracies from off on the street. And this isn't an inaccuracy from out on the street if right in court he says, no, it's accurate. It's his in-court statement under oath.
Judge.
It's not hearsay.
Judge.
You're not going to win this argument.
I understand, maybe not right at this moment, but I think after you've thought about it for 3 days, you'll realize you're wrong. Because the fact is, you know, okay, then let's say that the defendant were to take the witness stand and testify under oath, and then Mr. Albee is permitted to present to him every self-serving statement he's ever made before he got here. And the defendant reads this, oh yes, I told this person I was not guilty. Oh yes, I told this person I was not guilty. Oh yes, I told this person I'm not guilty.
No, there's a difference.
What is it?
He's adopting, and these are statements of, well, let me think about it.
There's no difference, Your Honor.
I think there is.
Well, your theory falls apart on that basis, because the fact is, it's an out-of-court statement, and the fact that he reads it in court and says, yeah, this is accurate, doesn't make it an in-court statement. It's still hearsay. And if your theory, which I know just came to you, and when you think about it, it's going to go away because it's not right. And it's an out-of-court statement that this witness made. Actually, this witness never even made it. It's an out-of-court document that somebody else prepared, and it's supposed to be a summary of a previous statement. It's an
What
out-of-court
is the
statement.
hearsay rule designed to prevent?
It's designed to prevent a waste of time by bringing in every single document or statement that a witness has previously stated and have them affirm it again in the witness stand. Okay. But really, we don't have to get into the theory underlying it, Your Honor, or the policy underlying it. We look right at the statute. We don't have to construe it.
No, that's when you make mistakes in evidence, is when you don't think through what the reason for the rule is.
Well, here,
you know what? I think that we may be arguing about something that's only tangential to the real issue here.
Okay, and what's the real issue then?
Well, if I could add two things. One, I really am not offering this for the truth so much as the matter that these are things he said. I'm not offering from the truth of the matter that he, because again, I want to use this document to show how he constructed this accusation against Mr. Jensen.
Well, if I admit it, other than the portion that is
it's simply that he said it.
Pardon me?
Simply that he said it.
But he didn't say it.
He
point,
said,
including on the witness stand just now, has he adopted the couple of sentences that are particularly pertinent to what we're haggling about.
Oh no, but I want
the rest of it?
I want the whole thing here. Yeah, I want the whole thing. But the other thing, Judge, and I direct this to opposing counsel, and I'll check my notes, but my feeling is I have a recollection that I was told how this thing, it was consistent with how I was cross-examining Mr. Dillard. My recollection is I was told how this was completed, which is that there was either a meeting or a telephone call or something before September 21st, and then on September 21st, it was read to him over the phone, or there was some sort of confirmation immediately thereafter that, yeah, that's accurate. I mean, that's why I cross-examined him the way I did. And I'm not saying I was told that. I'm just saying that was in my head for some reason, and so I guess I could inquire as to how it was completed without deciding who to call as witnesses.
Well, I didn't do this statement. Ms. Gabrielle did the statement, Your Honor, and I'll tell you all that I know. And
I'd be more interested in if Attorney Albee examined the witness about it.
And if do I understand you say that the witness may have said that he approved this statement over the phone?
No. My belief is that whenever I got this, or soon thereafter, I was having a conversation with the DA's office, somebody, either Mr. Jamboys or probably Ms. Gabrielle, about how this was compiled.
Okay.
And I'm just saying that when I was cross-examining Mr. Dillard, I started on the premise that I understood from prior conversations, which was, I thought that there's a meeting, this was typed up, and then he approved it in some fashion at that point, and then they sent it to me. And he says that's not what happened. Of course, I don't know.
No, here's what, and I don't know what happened, but I don't think, the witness was not asked if this statement was ever read to him over the phone. He said, I'd never seen this statement before, I never read it. I mean, I don't know if he was ever asked, did somebody read this statement to you over the phone? And I don't want to make, I don't want to go any further down the pike of making Ms. Gabrielle a witness in this case if that's something that can be avoided. If Mr. Dillard were to testify that this statement was read to him over the phone and he approved it, well, then that would be a different story. But that question I don't think was posed to him. He was asked if he indicated he's never signed the statement, and I think he's indicated he's never seen the statement. But I don't know that anybody has asked him if anybody read the statement to him over the phone. I know I never read the statement to him over the phone, and I can ask Ms. Gabrielle about that, but I'd prefer that we ask Mr. Dillard about it.
Well, we save a lot of time. Somebody told me something at one point, and it has slipped my memory as to exactly how this was compiled. And rather than ask Mr. Dillard and then be forced to call Ms. Gabrielle, it would seem to me to make more sense just to find out what the heck happened from your office's perspective.
What do you want to do?
I'd like to know what Angie had to say about it.
Did you read it? Ms. Gabrielle is telling me that she did read the letter to Mr. Dillard over the phone, Your Honor.
And did he indicate?
And Ms. Rosenke.
And did the defendant, or excuse me, did the witness indicate his approval of what it stated?
I believe he did, otherwise I wouldn't have sent it out.
Well, if that's the representation, then I'm going to admit it.
Well, no, I'd still object to it.
Why?
It's hearsay. It's a prior consistent statement.
Well, in some respects, it's inconsistent in the sense that they're not exactly the same.
And he's already acknowledged that.
But his acknowledging that they're inconsistent does not prevent the other party from showing that he's made inconsistent statements on the subject.
Well, I don't know that then.
Pardon me?
I don't consider these statements to be significantly inconsistent in any way.
And you know what? I think that's a fair argument to make to the jury, and they'll let them decide.
Okay.
But the question is whether I should let them have the right to make that decision, and my inclination, based upon what I've been told now, is that the answer is yes.
Okay. Well, Your Honor, and Ms. Gabrielle and I had not talked about that. So and I think it makes sense that she would read the statement to Mr. Dillard and his lawyer before sending it off to the defense counsel to make sure that's reasonably accurate.
So I'm going to leave it with the bias in favor of admission of the exhibit and permitted cross-examination starting on Tuesday.
Thank you, Your Honor.
All right.
That mark, that wall I have.
Pardon me? Did you have what? Oh, yeah.
I still object to that on other grounds.
Well, yeah, well, let's talk about that now instead of Monday or instead of Tuesday.
Put away everything.
Now, let me ask you, gentlemen, do I owe you anything in terms of any pending decision of any kind or any, do I owe you anything?
Judge, I have my motion to exclude recorded telephone conversations that I think the court has indicated that it's denying on a number of levels, but I'm not sure that everyone's been recited. Although as to more recent conversations, there was the additional ground of that I received 4 discs that contained many calls during the week before trial was scheduled to begin, is my recollection. And I don't have time to just listen to calls from Mark Jensen to his parents at various times, and I'm not told exactly what's there, and I don't have transcripts, and I don't have the resources to deal with those at this.
Well, is the state proposing to offer any of those?
No.
Okay.
If we do, if we're going to provide a statement or offer a statement of the defendant, and if we don't have a transcript, we'll provide him with a CD, which is what we would have.
But he says he did get it, and he hasn't got time to listen.
But we're not seeking to offer any of those. I mean,
That was what I asked. So neither he nor I needs to worry about it. He doesn't need to worry about listening to it, and I don't need to decide whether there's any ground to a motion of any kind. So
That is correct.
Anything else that I owe you guys?
No,
I don't know. I don't know where we are in various Dr. Long issues.
That one is still pending.
And
I'm waiting to hear from you, more information from you people. Anything else?
if we could approach for a moment, there's one thing.
Yeah.